Yes, Mr. Blackstone.
Yes, my lords, can I just very briefly return to paragraph 30 of the Court of Appeal judgment?
Yes.
Page 127 of the bundle. This may not be necessary, but of course the requirement for knowledge that the defendant, at the time the opinion or belief they expressed was supportive, derives itself from the recklessness element, because recklessness requires proof of an awareness of the risk. So the question I suppose arises was whether or not it's sufficient that there is an awareness by the person that there is a risk that their remarks may be interpreted as supportive of a prescribed organisation. In fact, the passage from the judgment goes further than that. But that does arise. But that, of course, is to be distinguished from the intent, specific intent, for the purpose of the original section 12(1)(a). As explained, obviously one may say in paragraph 52 of the Lady Chief Justice's judgment, when she says, in contrast to the word invite in section 12, which imports a specific intent, the mental fault element is recklessness. And can I just move on now? One of the problems in my submission with diluting the mens rea element to recklessness in the way that the section intended is that the problem is compounded in my submission by the definition of support. And we've made this point in our written case at paragraph 92. But can I ask the court to go to Chowdhury again? Paragraph 46, page 725.
725.
725, yes. And the principal submission of the appellants in Chowdhury was that the interpretation of section 12 involved proof that what was being encouraged, what was being invited, was practical support, and the court rejected that argument and held that, and this is letter E, in its ordinary meaning, support can encompass both practical or tangible assistance and what has been referred to in submissions as intellectual support, and then that's defined as agreement with and approval, approbation, or endorsement of that which is supported. Now, agreement with and approval are effectively passive concepts. Approbation or endorsement would require the person who's being encouraged to support to go as far as expressing approbation or endorsement. But agreement with or approval of, which is intellectual support, can be entirely passive support. And of course, it's not an offence in itself to passively support a prescribed organisation. The justification for restricting support to or extending support to intellectual support is that the more persons support an organisation, the more it will have what is referred to as the oxygen of publicity. But of course, that would only be the case if the person who is encouraged to support goes further than simply passively supporting an organisation. So that is, in my submission, a difficulty with the interpretation of the word support within Chowdhury. We submit that in considering the elements of the new offence, the court should consider whether or not support should extend to active support as opposed to passive support. It's not the same thing as practical support. Practical support is actually dealt with in section 15 of the Act, which is the terrorist fundraising provision. which means that, which is expressly excluded from section 12. So, effectively providing property or financial support is caught by a different provision and therefore is excluded from section 12. But in my submission, in order to ensure that the section does not trespass into protected speech, it must go further than simply encouraging passive support. And if one adds recklessness to the notion that the offence could be committed by encouraging passive support, there is, in my respectful submission, a problem here. And can I just really conclude in this way? And this is really to echo some remarks which Mr. Mansfield has made. I think they are worth echoing. The problem which was identified by Assistant Commissioner Neil Basu in his remarks to the Human Rights Committee about the issue of radicalisation of charismatic influences has been a long-standing problem, and we all recognise that. It was specifically addressed by the introduction of Sections 1 and Section 2 of the 2006 Act, which follows, my lords will remember, on the terrible events of the previous year, the London bombing and the attempted London bombing which followed, and the expressed concern at the time that more needed to be done to deter radical influences. And in particular, there was concern about an organisation called Al-Mujahirun. The court may remember that in particular, and of course Anjem Choudhury was closely associated, if not a member of, and of course eventually Al-Mujahirun was proscribed. But the offences in relation to prescription, in my respectful submission, do raise somewhat different issues. Section 1 of the 2006 Act prevents the glorification of acts of terrorism itself, so specific acts, and is accompanied by a recklessness provision. But when one's dealing with prescription, one is very often trespassing into areas which are the subject of legitimate public discussion. And it's not a coincidence that many of the cases which have come before the European Court are cases which involve the Kurdish organisation, the PKK, because there is continuing controversy about the prescription of the PKK and continuing controversy about the way in which the Kurds are dealt with by the Turkish regime. And it's also, if I may say so, no coincidence that this case, these two cases, come before this court against the background of the events of October the 7th, 2023, which has given rise to very strong views on both sides. It may be shocking or offensive to suggest that the actions of Hamas should be seen in their historical context, and that the prescription of Hamas was ill-conceived, given the treatment of Palestinians by the Israeli state, and the fact that the Hamas was the elected government of the Gaza Strip. But these are legitimate views. The problem is that if one expresses those views, there is a risk, in my submission, of prosecution under Section 12(1)(a, because anyone who expresses those opinions must know that there's a risk, at least, that whoever hears them will be encouraged to feel, at the very least, intellectual support for Hamas. And that is the chilling effect of this newly enacted, or this subsection. Effectively, and I support the point made by Mr. Mansfield, it has the tendency to stifle legitimate debate. So, my learned friends have submitted that Section 12(1)(a can be read down in a way which achieves compatibility. We submit that that's not possible, and for this reason. It's basically an Article 7 point. The difficulty with this section is the difficulty of anybody who is going to engage in this debate or even ventilate it in public, knowing what the limits are. It's all very well to say, as the government said in response to the Human Rights Committee, that the courts could deal with this on a case-by-case basis. Well, yes, but that doesn't deal with the problem that anybody who's deciding to speak on these issues has to decide what the limits are. And unless those limits are properly and well understood, in my submission, it violates the well-established principle that the law should be sufficiently clear to enable a person to regulate their conduct. There's no question that the terms of the Act are sufficiently clear. We all know what they are, but it's the application of the Act. That's the problem here. And in our submission, it's for that reason that it's not possible for this section to be read in a way which is compatible with the Human Rights Convention. Once the court has seen the response of the government in the papers which we provided to the court. So if I can just finally finish with this, and...
So you say it's got to be a Section 4?
Yeah, absolutely. Yeah, that's our point. That's our point. And there isn't a problem with that, actually, because you just go back to the original section, Section 12, which does the job. That's ours.
Well, sorry, if you've got Section 4, you don't go back to Section 12, the original form. You're left with Section 12, 1A.
Yes.
Being enforced.
But I mean, yes. My point, if avoidance of doubt, my point obviously is that Section 12(1)(a) is not a necessary, wasn't necessary to enact it, because there was a perfectly good provision which was being misconstrued. All that's required is for the existing section to be construed appropriately, so that an invitation to support can be either overt or implied. And very often it will have to be implied, and there'll be no difficulty in implying an invitation to support in most cases. And if necessary, the Act could make clear, the section could make clear, that an expression of opinion shall be deemed to be, or can be in certain circumstances, an invitation to support. That could be introduced by way of the statute. But to go on to withdraw the requirement that the person who is pronouncing should have him or herself intended that whoever hears it should support a prescribed organisation is a step too far in our submission and creates all sorts of problems. Those are our submissions, unless the court has any further questions.
Thank you very much, Mr. Blackstone. Mrs. Maybe.
My Lord, can I introduce the respondent's submission in this way by making three overarching points? First of all, the respondent submits that in relation to the Section 12(1)(a) offence, the ingredients of the offence themselves strike the proportionality balance in relation to Article 10, so that if they are proved, a conviction does not breach convention rights. Secondly, that conclusion is reached by examining the ingredients of the offence themselves, which are focused and relate to specific conduct and carry within them the requirement to prove culpability. And by looking at those ingredients and applying the analysis of this court in PWR and the Court of Appeal in Chowdhury in relation to the other offences within the scheme, and the submission of the respondent is there is nothing material to distinguish this offence from the offences that were considered in those other cases that would lead to a different outcome in relation to the proportionality question. So to put that another way, the differences in culpability and the penalty that have been identified do not distinguish this offence so as to lead to a different outcome. The justification in Article 10 terms is the same and sufficient. And thirdly, looking at what underlies that conclusion, the key context of the analysis is that Part 2 of the Act is concerned with the suppression of terrorism, and the terrorist context is the key factor in analysing the proportionality of any interference with freedom of expression in this area. The scheme of prescription is integral to the measures that Parliament considers necessary to combat terrorism and thereby meet a pressing social need of obvious and great importance, that being, in the end, the protection of life, the protection of a democratic society, and the protection of fundamental freedoms, which terrorism aims to destroy. And so, my Lord, in summary, the respondent's submission is that the decision of the Court of Appeal was correct, and in essence, the respondent adopts the reasoning of the Court of Appeal in reaching its conclusions. May I, in my submissions to the Court, do three things. First of all, look at the scheme itself and the ingredients of the 12(1)A offence. Secondly, address the approach to Article 10 and apply the relevant considerations to the section. And thirdly, make some submissions finally on reading down and how, if at all, that might be carried out. So beginning with the scheme and the ingredients of the offence, the starting point is the scheme of prescription. And my Lord, I don't propose to dwell on this because the points are well known. And there are many references in the authorities to this, but can I just simply identify one reference which really summarises the position and the point that the respondent wishes to make? And it's at paragraph 38 of Chowdhury at page 724. Which is the point about the scheme of prescription being integral to Parliament's response to terrorism. And the point that the Court is making is that the offences in Part 2 have been considered necessary to enforce the scheme and put it into effect. And there are other similar passages throughout the authorities. And one of the points made in PWR in this context, if I can take the Court to that at page 583, paragraph 77, at the end of the judgment. It was dealing with section 13, but the point can be made in respect of all of the Part 2 offences. Section 13 is a highly focused provision. The respondent would say all of these are highly focused provisions, aimed at ensuring that proscribed organisations do not obtain a foothold in the UK through the agency of the people of this country. And it is a restriction and it is a deterrence. And that is the context in relation to these offences. It is designed to choke the oxygen of publicity from these organisations, and the offence under consideration in this case is a further attempt to advance that purpose. And the Court of Appeal in the present case, I don't take the Court to it, but made references to that underlying purpose of Part 2. See paragraphs 28 of the judgment and paragraphs 51. It's how it frames the analysis before it gets to its 4 points. And so the overall point made by the respondent is that interferences with free speech in this area to enforce prescription has an obvious and readily identifiable justification in broad terms. Also dealing with Part 2 is this, my Lord. The scheme represents a carefully calibrated scheme of offences. That was a point made in PWR, paragraph 45, page 573. I don't take the Court to it. But
Sorry, the reference again.
PWR, paragraph 45, page 573 of the bundle. And my Lord, the calibration is in terms of two things: conduct and mental elements of these offences. And may I then say something about the scheme and the calibration and look at section 12(1) to begin with, to see where the new offence falls within that scheme. So, page 168 of the bundle, section 12 is set out, and the conduct that section 12(1) is concerned with is inviting support, and the point that's been made by my learned friend is that it wasn't necessary to enact 12(1)A because conduct that would fall within 12(1)A would be captured by 12(1). The response says that that is not correct. It may be the case that expressions of support for a prescribed organisation may amount to an invitation to support if they are of a particular nature and are sufficiently sustained, for example, or sufficiently specific, but not necessarily so. And that's why the wording is different. There is one mental element in subsection 1, and that is knowledge of the invitation, knowingly inviting support, and that was comes from the decision in Chowdhury. And may I make 3 points about that mental element? First of all, knowledge is akin to a specific intent. It's one of the highest forms of mental element in any criminal offence.
Is it different from intent?
No, it's not, because if you do something knowingly, as a matter of law, you intend to do it. Now, so the position is, my lord, that this is an offence of specific intent.
So we had this debate this morning about what specific intent meant and the concession which was made in Chowdhury. Are you able to help us a bit on that?
That was going to be my next point.
Don't take it out of me, please.
Because I can't know, but it appears that what the court may have been referring to is an absence of specific intent in relation to result.
Right.
Because there is no mental element or concern in subsection 1 with the result of the invitation.
I see.
And that is, so the implication of that, or the result of that, is it captures people who invite support, knowingly invite support, but have no interest or concern in the outcome. And the classic example may be an intermediary who publishes the invitation. They may not care one way or another what the outcome is. And it's consistent with this being a provision focused on the invitation itself. That is the vice, because that is where the oxygen of publicity comes into being. And inviting support in itself is a culpable act in relation to a prescribed organisation. So those are the points that the respondent would make in relation to subsection 1. In relation to subsection 2, the conduct is set out, and it obviously relates to a meeting. And again, knowledge is the mental element in relation to that. It's arranging, etc., the meeting which he knows is A, B, and C. And it's plainly the case that the requirement that what is happening is in connection with a meeting means that not all conduct that falls within section 12(1)A will fall within subsection 2. Subsection 3, the mental element it's akin to intent as well. It's doing something for the purpose of his address. And again, it relates to a meeting, and so conduct that falls within the new offence will not fall within subsection 3 if it doesn't take place within the context of a meeting. So, the points here is that Section 12, in those three offences, is dealing with specifically focused conduct of a certain character with a mental element which is basic specific intent or akin to it. Then comes the present offence, Section 12(1)(a). Now, in terms of conduct, the offence goes beyond subsection 1, because the conduct in subsection 1 is inviting support. And it may be said that the conduct in subsection 1a is a lesser form of conduct. It is expressing an opinion or belief, rather than actually a positive invitation. But the ingredients of the offence, if I can list them as the respondent submits, it's first of all that the accused expresses an opinion or belief. Secondly, that the opinion or belief is supportive of an organisation. Thirdly, the accused knows that the opinion or belief is supportive of the organisation. Fourthly, the organisation is proscribed. And fifthly, the accused is reckless as to whether a person to whom the expression is directed will be encouraged to support the organisation. And those ingredients the respondent submits are focused. They deal with the content, context, and impact of the speech. And of course, in any case, there will be a factual analysis of whether what has been done falls within those ingredients. But the respondent submits that proof of them would result in a conviction being proportionate in Article 10 terms.
Are you going to come on to the question of what opinions or beliefs are actually being targeted by this offence? It's a very live issue in the case of a first appellant.
It is, and so what will have to be proved in her case and in any case is that the opinion or belief was supportive of the organisation, supportive of Hamas in her case.
And you accept, do you, the Lord Chief Justice's distinction between expressing an opinion or belief which is supportive of the objectives or aims of an organisation on the one hand, and being supportive of the organisation itself on the other hand?
Yes, the respondent does, and the respondent submits that's a fundamental aspect of the analysis in this case, because when the question of whether an expression is supportive of an organisation is considered, there are really two aspects to it. The first is the expression supportive at all? I mean, supportive has a substantive meaning. It's said it to be broad. It is broad, and it's understandable why Parliament has not restricted it to certain types of support. And ideological support is one of the reasons why this offence was enacted. It's about radicalisation, as the documents that the court was shown this morning showed. But it is broad, but it also has depth. It has to be supportive in fact. But secondly, and this is the point that my Lord asked me about, it has to be supportive of the organisation, not the aims and objectives of the organisation, but of the institution. So it has an institutional aspect to it. Now, it's right to say, my Lord, that of course, depending on the facts, it may be that in a particular case, expressing support for aims and objectives in a particularly specific way may be supportive of the organisation itself. It would simply depend on the facts. But to take the example that was given, expressing support for a free Palestine or a united Ireland is very different from expressing support for particular organisations who share that aim. And
equally, if you express support for the killing of the Israelis in October 2024, in ignorance that Hamas was responsible for that, you wouldn't be expressing an opinion that was supportive of Hamas.
That is...
Is that right? You need to know that Hamas is responsible.
Yes, I think that would almost certainly be the case, if not absolutely be the case, because the offence requires knowledge that it is supportive of the particular organisation, and what's more, the accused has to be reckless in relation to further support, or the encouragement of further support of that particular organisation. So there's a double aspect to the supportive and the institutional aspect of the offence. So and the submission of the respondent is that makes this offence focused. It restricts its ambit to within proper bounds because it is focused specifically on the scheme of prescription. Rather,
that must, in a sense, be right, mustn't it? Because we could think of many organisations who would, let's say, support United Ireland.
yes.
But maybe only one, two are proscribed organisations.
Yes.
So one has to make that distinction. I suppose the case against you is that's all right in principle. It's more difficult when it's applied to particular facts. But I guess you would say, well, the judge is going to have to make that clear to the jury in a well put together summing up, perhaps with examples to make clear where the distinction lies.
Yes, and doing it in that way is not the special province of terrorism offences.
No,
It may be in any case, some speech or any act that may be criminal, may be close to the borderline, it may be ambiguous, there'll be competing arguments. And in the end, it has to be resolved on the facts after judicial direction in accordance with the criminal burden and standard of proof. But that's not unusual, and there'll often be borderline cases.
But in a case like this, where like that of the first appellant, who says nothing whatsoever about Hamas, but she expresses opinions which are supportive of Palestinian freedom fighters fighting back against Israeli oppression. On what basis could she be convicted?
Well, the prosecution would have to prove that what she was doing, her conduct, was in fact supportive of Hamas, and that she knew that. And that can only be done by interrogating the facts. Now, what the prosecution would say, I would imagine, is that by saying what she said on the day that she said it, given the publicity, she must have known that her words, must have intended that, her words to be supportive of Hamas. It was known by that time that Hamas were principally responsible for it. That's a contested issue at the trial in the defence statement.
Well, but there must be more to it than just hand it over to the jury. I mean, if, for example, there was an IRA bombing in London, and the next day somebody with a loudhailer at Speaker's Corner said, I support a free Ireland, we need to fight British oppression, would that be supportive of the IRA?
It seems unlikely because it's non-specific.
Well, our case here is non-specific.
Well, the facts would always have to be interrogated. So, for example, I don't think it's in the statement of facts and issues, but there was another speaker immediately before this appellant who spoke about this in terms of this is what Hamas has done. So there are surrounding circumstances that would have to be interrogated. She was in possession of, at her home, she was in possession of Hamas literature or literature relating to Hamas. So there are inferences to be drawn from the surrounding circumstances. But I suppose, my Lord, there are just on the procedural point, if at the close of the Crown's case, the evidence is non-specific and not capable of sustaining the prosecution allegation, then procedurally that will be the end of the case before it gets to a jury.
Yes. I suppose the impact of the language, we're interested not just in what she knew, but on its impact on the audience.
Yes.
And so you say that her speech isn't to be seen in isolation from the context in which it was delivered. And the context, you say, is one in which there had been prior references to Hamas, which made it clear that in her speech, that's who she must have been referring to.
Yes, that's the prosecution.
That'd be the
case.
gist of the Crown case.
Yes. So, it goes beyond. There are other factors rather than simply the words on the page, and it's likely that will be common in many cases.
Yeah.
So,
can I just come back to your knowledge requirement? I assume that this is just standard, that one will often have criminal offences described without a clarification of the mental element, and the courts therefore, just as a matter of normal interpretation, nothing to do with the Human Rights Act, just find that there must be a mens rea involved. That's what you're saying, that we get the knowledge, that the defendant must know that the opinion or belief is supportive of the organisation. I know that we've got that now from the Court of Appeal.
yes.
But if we were deciding it, the argument would be that's implicit in the legislation.
Yes, by necessary implication. I mean, a case where it happened was actually PWR, where there was the Section 13, the provision is displaying an article.
Yeah.
And one of the points that was being made is, well, what happens if you don't know you're displaying the article because someone's stuck a sticker on your backpack? And this court, my lord, held that by necessary implication, knowledge of the display was an ingredient of the offence, and it's the same here.
And you say knowledge in that particular part of the offence is to be equated to intention.
Yes.
So the implication of what you're saying is that the speech that we have set out that was delivered by the first appellant in one context might not constitute an offence, but in another context might do.
That is correct, yes. And that is a product of the substance of the ingredients of the offence. That's really the point we're making. So it's not any speech. There are hurdles, substantive hurdles that the prosecution must overcome, which are both objective in relation to the support or the nature of the speech in terms of support, and subjective. And that is a focused, coherent and substantive way of constructing an offence that interferes with free speech.
I suppose in general terms that must always be the case, isn't it? You can have the actus reus of a crime, position 1, actus reus of the crime, same position 2, but one's got the mental element, one hasn't.
Yes. Yeah. Or a different mental element takes you to a lesser included offence, for example.
Mr. Mabley, can you help me on this, please? If knowledge that the expression of opinion or belief is supportive of the organisation in question amounts to the same as specific intent, isn't that requirement diminished by the provision in 1A in relation to recklessness?
In my submission, it's not diminished, it's supplemented. Because the intent or the knowledge in relation to the conduct element of the offence relates to the nature of the language.
Thank you. So when you say knowledge that the expression of an opinion or belief is supportive of the organisation in question is the same as specific intent, you mean specific intent in relation to the actus reus.
Yes.
Yeah.
Yes, the conduct.
Thank you.
Thank you. And so the mental element, which is dealing with the harm, is recklessness. And of course, this is now a way of structuring the offence which is not present in subsection 1, which is silent as to the potential harm. But the additional ingredient then is an ingredient of standard recklessness.
I see that from paragraph 30 of the Lady Chief Justice's judgment, it was common ground that the defendant had to know that the opinion or belief was supportive of the organisation. There was no discussion of this before the Court of Appeal, as I understand it, therefore. I mean, you rely on the sort of statutory presumption of mens rea, really, don't you?
Yes, and
Where you get to it.
Also, because there is an element of recklessness.
No, but before you get there, just on the question of, because I think this is what Lord Burrows was asking about, the knowledge that the statement is supportive.
Yes.
So he's got to be objectively supportive of the proscribed organisation, but the speaker must also subjectively know that it is supportive.
Yes.
And that element was common ground in this case.
It was common ground. I must confess, I can't remember whether there were submissions on the point before the court.
Before the court below? Or?
The court below.
Right.
But there are perhaps just 2 points to make about that. The first is the agreed position, which the court accepted, is consistent with Chowdhury.
Well, Chowdhury, remember, used the word invite, and it's very difficult to see how you can unknowingly invite.
Yes.
So I'm not sure Chowdhury gives a basis for it. I imagine it's more, just as I say, isn't it a statutory presumption?
Well, that is part of it, but there's also, but just dealing with recklessness.
Well, that's the other element.
Yes, but thinking about how someone can be reckless, the recklessness requires the appreciation of the risk that someone will be encouraged to support the particular organisation. It's very difficult to prove that unless there's prior knowledge that you are supporting.
Yes, sorry to interrupt you. Yes, I see. Yes.
And the point that the respondent makes about the place of recklessness in the offence is it's an additional fault element that's not present in subsection 1. And
I mean, subsection 1 isn't directed to the effects at all.
No, exactly.
You've got the invitation of support. Presumably you're hoping that they'll support, but you might be talking to someone who's deaf to your pleas. There's no question of you having to assess that they're likely to support or anything like that.
And you may not care. You may just, the money, put it on a website, put the invitation on a website. And recklessness here then is an additional ingredient, and it is obviously a culpable state of mind, a blameworthy state of mind in relation to outcome. So what the respondent says is, in fact, the recklessness element of this offence is not a dilution at all. It's an additional ingredient. If there is a dilution, if there's a difference, it's actually in the conduct that this criminalises, which is the expression of support rather than an invitation. So that's the way the respondent analyses the ingredients of the offence. May I then say something about the approach to Article 10? Because plainly, if an offence interferes with Article 10 rights, it must be justified, and part of the justification is the proportionality. And as was put this morning, and the respondent adopts this analysis, there are different ways in which proportionality can be ensured. And one of those ways is for the legislature to make provision for ingredients which themselves take account of questions of proportionality. And this was looked at in the Attorney General's reference case at page 224 of the bundle, paragraph 68. Above paragraph 68, there had been, this was the Coulston statute case.
This was what, sorry?
So it's paragraph 68, page 224. And above paragraph 68, there had been a discussion about the authorities. And at the end of 67, the Lord Chief Justice said that a criminal conviction is one of the most serious forms of interference with the right to freedom of expression. And he had previously referred to the stricter scrutiny that requires. And at 68, however, does stricter scrutiny mean that a fact-sensitive proportionality assessment must be carried out in every case where criminal conduct engages the rights? Or can the call for stricter scrutiny be satisfied by a court deciding whether proof of the ingredients of a particular offence is sufficient for a conviction to be proportionate? And he answered those questions. The first question, no. So fact-sensitive proportionality assessment need not be carried out in every case. And the second question, yes, can be satisfied by proof of the ingredients of the offence. So this is the court saying, in Attorney General's reference, that the ingredients themselves can strike the balance. And then, may I then refer to...
Well, I think this is the Lord Chief Justice, is that
Chief Justice, yes.
I mean, I think he's also making the point that you can get a sort of distribution of responsibility amongst different institutions of the state. So it may be that the definitions of the offence, effectively, once the jury have applied their minds to whether they're made out, does practically all the work.
Yes.
Under proportionality, but you might get some cases where it doesn't do all the work, in which case other questions might have to be asked, I suppose, of the jury in order to make sure that between legislature and court, the whole ground has been covered.
Yes, and the respondent agrees with that analysis, and that is the analysis which my Lord set out in abortion service. My Lord Reid set out in abortion services. So can I just take the court to that, because the respondent relies on this this analysis. So it's at page 534, going on to 535. So the analysis is paragraph 54, where the rights are raised. The first question is, are the rights actually engaged? Paragraph 55 is the second question, is are the ingredients of the offence themselves, do they strike the proportionality balance? So that if they're made out, the defendant and the defendant's convicted, there can have been no breach of his or her convention rights. And the respondent says that is the case in respect of this offence. So going down to F in paragraph 55, this is a case where proportionality is inherent in the ingredients of the offence. And the point that is also made in the sentences that follow is that in striking that balance, the decision maker, in this case Parliament, enjoys a margin of appreciation. And the courts will therefore accord that an appropriate degree of respect. And then paragraph 56 deals with the point that my Lord Sales was referring to. What happens if that is not the case? And this is the third question at the very bottom of the page. If the ingredients of the offence don't strike the balance themselves, whether there is a means by which proportionality of a conviction can be ensured. And there are essentially two ways of doing that in terms of criminal procedure. One way is to give words in a statute an enhanced meaning. and that is what the Court of Appeal did in the case of Casserly in relation to the offence under the Malicious Communications Act of sending a grossly offensive communication. The case is in the bundle at 698. And so what the court said there is grossly offensive has a substantial meaning and has to take account of the fact that people can't be thin-skinned if they're politicians. They have to expect criticism. And the jury is directed accordingly as to that definition. The second way of dealing with it, and this is again is paragraph 57 of abortion services, is that there may be words in the section along the lines of reasonable excuse or lawful excuse. That may be an ingredient of the offence, or it may be a statutory defence that attaches. And so the position would be, for example, if a conviction was disproportionate, it would mean the defendant had a lawful excuse or a reasonable excuse, as the case may be. That was the analysis. And the question is, in that case, is who makes the decision? Is it the judge or is it the jury? And this is something that my Lord Reeve examined or referred to in paragraph 67, which is the body that is responsible, and stated that assessment of proportionality in criminal proceedings, running the sentences together, need not be carried out by the body responsible for determining the facts.
Well, that was that was a case from Northern Ireland where whereas in Scotland these issues can arise by way of a plea and bar of trial.
Yes.
And the point I wanted to emphasise was that you have to look at the criminal procedure of a jurisdiction in question to see the appropriate way of dealing with this.
Yes.
And it clearly wasn't, that was an appeal from Northern Ireland, so it clearly wasn't an appropriate case to try to work out how these things should be dealt with in England and Wales.
Yes. Can I make a submission that in England and Wales, it is would never be for the jury to decide the question of proportionality as a freestanding matter, even if it is imported within a lawful excuse or reasonable excuse defence or ingredient. It would always be a matter of law for the judge. Can I say something about that submission? The reason that the respondent makes that submission is both principled, but also has regard to the practical realities of a criminal trial. A point of principle is that proportionality is not a matter of fact. It is a matter of law. And the cases that were referred to this morning about juries, cases of Wang, are irrelevant to this question. Wang is simply a case which is authority for the proposition that if a matter is properly a matter for the jury must determine it, and a judge cannot direct a conviction. That's all Wang is authority for. But it begs the question, is this a proper matter for the jury? Now, in abortion services, my Lord, the nature of the proportionality assessment was examined, and at paragraph 30, the point was made that the assessment is not an exercise in fact-finding. It involves the application in a factual context, often not in material dispute, of the series of legal tests which my Lord had set out in a previous paragraph, paragraph 24, together with a sophisticated body of case law, and may also involve the application of statutory provisions such as sections 3 and 6 of the Human Rights Act or the development of the common law. And a proportionality assessment may involve examining various materials. In this case, there's a submission from the Secretary of State referring to underlying documents. There's parliamentary materials. And so there may be a whole range of matters that are relevant to a proportionality assessment. Now, it's different if the judge makes that decision and gives a word a heightened meaning and directs the jury accordingly. That's one thing. But simply importing a proportionality test into a criminal statute by the route of lawful excuse, let alone a freestanding proportionality test, which Learned Friends have contended for, would import the full range of the assessment into the jury room. But as a matter of principle, that is not a matter for a jury. The role of the jury is simply to decide whether the facts are sufficient to have made out the ingredients of the offence to the criminal standard.
So if the question of proportionality is bound up with, say, the question whether there's a reasonable excuse, reasonable justification,
yes,
you accept that has to be left to the jury?
No. That is a matter of law for the judge. If it's bound up with a reasonable excuse or lawful excuse. Because what the judge will be doing is conducting the judge in the Crown Court, conducting the full proportionality assessment, giving a reasoned judgment, and if the judge decides that a conviction would be disproportionate, the effect of that decision in the context of a lawful excuse or reasonable excuse ingredient will be the judge will be finding that the defendant did have a lawful excuse as a matter of law, and therefore the prosecution could not prove that ingredient of the offence, or alternatively the statutory defence was made out, and therefore there is no case to answer. So the direction to the jury would be a direction to acquit, which a judge obviously can direct the jury to acquit.
Or if it was dependent, forgive me, if it was dependent on a particular conclusion of fact, then the direction would be that if you conclude X, then you must acquit. Exactly
so. And just on contested facts, there are 3 points to make about that, because obviously the facts are for the jury to determine in accordance with the burden and standard of proof. When it comes to Article 10, very often the facts are not in dispute. So sometimes the speech is the speech. Not always, but sometimes. Secondly, a judge considering this matter, if there is a dispute of fact, would have to decide whether that dispute makes any difference to the proportionality exercise. Because it may not. It may not matter one way or the other. Because the defendant may be saying, well, even on the prosecution case, Article 10 protects me and it would be disproportionate to convict me. So the dispute may not matter. But thirdly, if it does, the position is, as my Lord said, and it's common in many criminal cases in other contexts, where something asserted by a defendant would, if true, mean he or she was not guilty. It's simply saying to the jury, if you are not sure that fact X is proved, the defendant would have a lawful excuse, and then your verdict must be not guilty. So within English criminal procedure, there is a very straightforward way of dealing with a factual assessment in a trial that doesn't involve placing these encumbrances on the jury.
So you say that proportionality is always a question of law?
Yes.
Yeah. So you would then postulate that the judge would have all that responsibility, although, of course, the application of aspects to it, to particular facts, as you've just explained, would throw that question to the jury. But that's not the proportionality question as such.
Yes.
Can I ask, the argument against you on behalf of the first appellant is that the offence has to be, as set out in the statute, has to be read down in the light of Section 3 of the Human Rights Act, so as to build into the ingredients of the offence the proportionality of a conviction. Now, if that becomes an ingredient, does it not have to be reflected in the indictment?
Well, it would do, but the response of the respondent is that that should not be read into the...
Yeah, well, I was wondering how one follows this through in terms of criminal procedure.
Yes.
Because if it's part of the offence, you'd think it would be part of the charge in the indictment.
Yes.
And if it's part of the charge, you might think it's part of the matter confided to the jury.
My submission, my lord, is that Section 3 of the Human Rights Act wouldn't permit such an insertion. It's just a completely new, unintended ingredient of the offence. And the position is, if it can be attached to an existing ingredient, that's one thing. That's one use of Section 3 which would be permissible. But the court can't, as it were, rewrite the statute. And
we don't have it in front of us, I don't think, but the leading case is Guyden and Godin-Mendoza, and the test is whether the suggested change to the statute would go with the grain or against the grain of the legislation.
Yes. And in my submission, it would go against the grain because Parliament has set out the specific ingredients, focused on a particular purpose, taking into account, it may be said, its obligations under the Human Rights Act, or the obligations under the Human Rights Act and the Convention. And to import such a wide-ranging ingredient gives the offence a whole different aspect to it. It's now a...
I think what you're saying is that when one judges whether an insertion is going with the grain or is contradicting a cardinal feature of the legislation, which I think is the other part of the formulation in Guyden, you have regard to the procedural environment in which this legislation is supposed to operate, which has implicit in it the division of function between judge and jury, where the jury would, I think you'll say, be wholly ill-equipped to make the conclusion, which is a legal conclusion, on proportionality. They might be equipped to make factual findings which could feed into that.
Yes.
But insofar as the ultimate proportionality assessment has to be made, that's for the judge because it's an issue of law. If the judge identifies particular factual predicates which need to be determined to reach a view one way or the other, depending on how far one could go under Section 3, the judge might be required to formulate directions to the jury which directed their attention to those particular factual matters, but the ultimate conclusion in the light of the assessment of the law would be the judge's, because he's directing the jury.
Yes. I
suppose at the end of the day, the direction would be, if it was of that sort of character, that the judge would say, if you are sure that this and this factual matters are established, the this and this being what would be required to make the conviction proportionate, then you convict, otherwise you acquit.
Yes.
And so that would not be the jury deciding on proportionality. They'd receive a direction on the law on proportionality from the judge, but the factual steps along the way, if there were any, would then be for the jury.
Yeah, exactly so, my lord. And just as a matter of practice, in the Crown Court, judges at the end of a criminal case give the jury a routes to verdict document. So it be in writing and it will be very clear. But it doesn't involve... It keeps the jury's function within its proper province.
Yeah, the judge is directing them as to the law.
Yes.
He's not leaving the legal conclusion to them. Yes. He may be leaving conclusion on particular facts to them and leaving the question of conviction or not to them, but that's in the light of what he has held the law to be, he or she has held the law to be.
Exactly so. And...
But I mean, you're not suggesting that this isn't possible. I mean, assuming we were to accept the submissions of the appellant, you would accept, I assume, that the judge can formulate appropriate legal directions and then tell the jury whatever the factual remit is for them, this is the law that you must apply to those facts. I mean, it's not as if it's... I mean, we've got Casserly as a great example, as I understand it, of where the Lady Chief Justice actually said this is what a judge ought to be ideally directing the jury to do in a case where we're within what I find quite helpful, category 3,
yes, rather
than category 2,
yes,
i.e. one where it's not baked into the legislation as such. And that seems, well, it seems to have been achieved there.
But the judge did that in Casserly in a slightly different way. It was the heightened meaning
of grossly offensive.
Of grossly offensive.
Yeah.
And so, the effect of what the judge has done, because that's obviously binding authority on the Crown Court,
yeah.
The judge, the Lady Chief Justice, by reason of that decision, has now pulled that particular offence up into category 1, or within question 2, I suppose.
Not category 1,
not
category 2.
Category 2. So the ingredients of the offence now themselves are sufficient.
Yeah. But I mean, that's through a process of, as I understand it, of interpretation of the ingredients of the offence.
Exactly.
So that's still the law. Section 3 is a way of working out what is the law that we're applying in this particular case. If there's an issue of doubt about proportionality, a judge might have to go through a Section 3 exercise in order not to arrive at a conclusion, so the shortcut, leave it to the jury. Oh, jury, is a conviction proportionate? But actually to do what one might say is the hard work of working out what in legal terms the ingredients would need to be in order for the ultimate conviction, if there is one, to be proportionate. But then having identified those ingredients, put the ingredients to the jury by way of legal direction rather than leaving the matter completely at large to the jury.
Yes. Can I make, the respondent respectfully agrees. Can I make 3 points about that and about how this may work? One is a general point, really, to reinforce the submission I'm making about it's not a matter for the jury, it's a matter for the judge. And the other 2 points are actually about the procedure by which the judge does it. The general point as to why it's, as a matter of practice, unhelpful to leave it to a jury, apart from it's not within the competence of the jury, of course, don't give reasons. So if it's left to the jury, you get an unreasoned decision on proportionality, and there would then be a question mark as to whether there could ever be an appeal on a proportionality basis. Because ordinarily, a court of appeal would decide for itself. But you run into the case of the principle in Pendleton, you can't go behind a jury's verdict. So it's inconsistent with merging facts and law. And then the point of procedure is this. My Lord Burrows said it's not impossible to do it in this case. It's not impossible in any case as long as the assessment can be tethered to an ingredient of the offence, rather than in the abstract, because there may be some offences where there is no ingredient which proportionality can attach to.
My understanding of my Lord's question was that it was directed to possibility, as that term is used in Section 3 of the Human Rights Act. And I have to say, I understood your submission in effect to be it's not possible in those terms to write in an ingredient of an offence which simply leaves the proportionality question completely baldly and at large to the jury.
Yes.
Because of one's interpreting all criminal legislation against the backdrop of the criminal procedures which Parliament's familiar with, we're familiar with.
Yes. That is my submission.
Yes.
So I think the way I was putting it was, I accept entirely, it's much more straightforward if you've got reasonable excuse, grossly offensive, an ingredient of the offence to which one can feed in proportionality. But I'm not sure this really matters to your case, actually, but I think I was just saying that if you can do it there, it must then also be possible to envisage a freestanding proportionality defence where the judge has the responsibility of clarifying the precise ingredients of proportionality and the jury then applies it. I mean, you may say, well, that's using Section 3 to go too far.
Yes.
It's against the grain
Yes.
of the legislation. Well, I understand your submission.
That is my submission.
Yeah.
The judge can only bring in proportionality to the assessment in a way that is consistent with a principled application of Section 3. And that is the point in abortion services that my Lord Reid made at 59. If interpretation...
Sorry, can you help me with the page?
Sorry, it's page 536, paragraph 59. So this is in a case where the ingredients of themselves don't strike the balance. You've strived to bring in proportionality by looking at the ingredients of the offence, reasonable excuse, or heightened meaning. But if there's no way of doing it, and Section 3 can't be used in a principled way, in a permissible way, then you're left with incompatibility, and you have to apply the statute. What you can't then do is say, well, I'll decide proportionality in a freestanding way and import it without it being tethered to the statute.
I mean, I think it can be said paragraph 59 doesn't directly address what we're now debating, but you say the possibility under Section 3 does not extend to writing in a completely freestanding proportionality defence, and that then leaves one in the position identified by my Lord in paragraph 59, because then you've simply gone through Section 3. Can I change it? No, I can't. You just have to apply the statute then.
Yes. And can I make one related point to that, supporting that proposition? And it's just to pick up something that was raised by my Lord Reid in paragraph 67 of abortion services, where another possibility was raised. It's right at the bottom of the page, 537 at H. And this, my Lord went back to the Section 3 of the Human Rights Act interpretive obligation, and then refer to the possibility of some other procedure, such as an application to stay as an abusive process, which is a jurisdiction available in any criminal case. But the respondent submits that wouldn't be an appropriate jurisdiction to consider proportionality because it's untethered to the statute. It would essentially be a freestanding assessment of proportionality. It would be saying, well, the ingredients of the offence are met. That either judge can't resolve proportionality by reference to Section 3 of the Human Rights Act.
No, I mean, there would be no abusive process then. You've simply got a statutory provision. It has a particular meaning. The court seeking to apply that statutory provision. Where's the abusive process?
Yes, this is a very general discussion.
Yes,
here.
I know.
Floating ideas, because this case, abortion services, was decided against a background of a lot of problems being experienced in criminal courts.
Yes.
I mean, you could, for example, have a common law offence where Section 3 and Section 6 wouldn't apply.
Yes.
But where you might nonetheless the court might be under a Section 6(1) duty not to reach a verdict which would be incompatible with convention rights.
Yes.
And in that sort of context, you might be looking at common law ways of resolving the problem, of which a stay is one possible approach.
Yes. It is right to say that this issue has caused problems in the lower courts, and the problems are, contrary to what's been submitted, when juries, as they sometimes are asked to decide proportionality on a broad basis, and you get routes to verdict which are 20 pages long and closely typed, and everything breaks down. That's the problem. And there's our submission, there is a perfectly straightforward way through it, consistent with the usual position in English criminal procedure, which is to let the judge decide and give the jury appropriate directions. So against that backdrop, the respondent submits that looking at the ingredients of the offence in this case, Parliament has properly struck the balance. And there's actually no need to deal with reading down or looking at importing questions of proportionality into the Section 12(1)A offence. So those are the respondent submissions.
So you say this is a Category 2, but
Yes.
not a Category 3 using
Yes.
Lady Justice R's and ours. Yeah, thank you.
Well, thank you very much, Mr. Mabley. Well, I think, Ms. Mansfield, you may have used up all your reply time, unless Mr. Blackstone wants to share some of his with you.
Yeah.
Mr. Greenhall may want to share some as well. Many of the submissions are directed towards proportionality, and he's the person who's been dealing with that. Yeah. So perhaps.
Yes.
Is the person doing?
If I might trespass a bit into the time that's been generously given to me, and just to pick up on 3 points. The first, just to put it on the record, reference was made in relation to the case of ABJ to Hamas literature that was found. Just to be very clear, there was no literature in possession of ABJ that was produced by Hamas, and no evidence of that. When she made the speech, she was not aware that the events on the 7th of October were attributed to Hamas. And as indicated in the defence statement, there were particular personal circumstances for her limited knowledge, and I don't go into those in open court, but it's page 141 of the bundle. In relation to proportionality, and just to address the points made by my learned friend about the approach that could be adopted, and the suggestion that if a proportionality assessment is required to be made at trial, the way to do it is for the judge to craft a direction to the jury to the effect that if facts X, Y, or Z are found, then they must acquit. The first point is that the judge's role is limited in that he or she can only give a direction that they must acquit in certain circumstances. He could never give a direction that they should convict. Also, in my submission is basically in practice, the approach suggested by my learned friend is in fact more complicated than asking the jury directly to make the assessment of proportionality themselves and to apply the law to the facts. There will be many factual elements which can bear on proportionality. Just in the context of a speech offence, what exactly was said, what its exact impact was, how much of that impact was due to the the defendant's actions, how aware the defendant was, what the importance of the issue was. Those are not all necessarily binary questions, and those would need to be taken in all sorts of combinations in order to say, well, this combination would render conviction disproportionate, this combination wouldn't, and so on. And you end up with a direction that is far more complicated than simply to ask the jury the Bankmail Act questions. Is the aim sufficiently important? That will not be in dispute. Is there a rational connection? Question of less restrictive measures. And then ultimately, is there a fair balance between the rights of the individual and the general interests of the community? And that, in almost every case, will be the key question. And just asking that of the jury, it's a one-line question. They can have a short direction about the sorts of factors that they would want to consider, importance of free speech, importance of the issue, the impact of the conduct, etc., etc. That those factors can be readily listed, and then it is for the jury to apply, and that is in accordance with the approach as set out in Wang and in Stonehouse, and in particular the speech of Lord Keith in Stonehouse, and what he says in relation to the division of labour is that it is always for the judge to set out the law and for the jury to apply that law to the facts as they find them to be. If I might just have one moment to get to the exact reference. Paragraph 63 of the written case, it is the function of the jury, on the other hand, not only to find the facts and draw inferences from the facts, but in modern practice also to apply the law as they are directed upon it to the facts as they find them to be. I regard this division as being of fundamental importance, and I should regret very much any tendency on the part of presiding judges to direct juries that if they find certain facts have been established, then they must convict. Well, this would be the converse of that, and goes against the grain of that approach. My learned friend made reference to difficulties in the lower courts. I have made inquiries in terms of jury trials. I'm aware of 9 jury trials where proportionality has been left to the jury. There has never been a question from the jury expressing difficulties with the direction, asking questions of it. They've been able to deal with it. If the court requires the details, even the routes to verdict, then that can be provided, but routes to verdicts have not been generally 20 pages long, or at least not on the proportionality exercise. It can be done quickly and is no more complicated than directions to juries on other elements of criminal law.
And in those 9 cases, it was a freestanding direction, was it? Not enhanced meaning to a particular term or tethering it to the ingredient of an offence?
It was a freestanding, yes. Yeah. I mean, in a number of them, there were other defences as well, so it wasn't the only defence, but proportionality was left as a freestanding defence.
I mean, just before you leave that point, what do you say about my Lord's judgment in the abortion safe zones case at paragraph 30, page 5 to 8, where he makes the point that determination whether an interference with the convention right is proportionate is not an exercise in fact-finding. See, it does occur to me that it might be said, although in a certain sense it's very easy to say to the jury, you've got the 4-stage bank ballot test, what do you think? But actually, that test has a whole lot of glossing, legal glossing, over it in terms of case law from Strasbourg, case law from the higher courts in this jurisdiction, so that if a proportionality question arose before a judge, they would have to work their way through all these legal authorities and come to a conclusion, rather than just sitting down and asking themselves, well, there are these 4 points, what do I think now? In other words, it's a very directed inquiry. Well, let me put it to you. That seems completely inappropriate to put to a jury in that way.
My response would be that in the context of a given case, the relevant factors will crystallise into a finite list, and those can be set out to the jury. They can be directed. For example, if one considers the case of Ziegler, that's an obstruction of the highway case, but there's a reference there to the relevant factors to consider, and this is direction to district judges in the magistrates' court primarily, but it is, was it a very important issue that they were protesting about? What was the extent of the disruption? What alternative means to protest were there? Was the location of specific importance? When one takes a given factual context, the list of factors reduces, but the assessment of those factors, the weight to be given to them, and the balancing exercise, in my submission, that is for the jury, rather than to try to create a table of combinations that this combination should result in acquittal and this won't. That gets more complicated, and it really does reflect the constitutional role of the jury in the criminal justice system, that when weighing up the value of free speech and the rights of the community, 12 members of the jury are at the heart of our criminal justice system, and properly directed, they are the ones, in my submission, who should make that assessment.
I think it's put against you that you are taking as read that they are questions of fact, whereas if one looked at it from the other end of the telescope and said, actually, there are issues of law involved there, what you're doing then is jury A is taking a view on the law, jury B is taking a view on the law, and we've got like cases not being treated alike as a matter of law, which is also unacceptable, I would have thought.
I think I accept that the application of the proportionality assessment in a given context is it's a mixed question of law and fact. It's the application of law to facts. And the role of the jury in even outside of convention cases. I made reference to gross negligence manslaughter. Again, structured questions about what amounts to gross negligence. It's for the jury to do that application exercise. And in terms of whether there is a risk of different juries coming to different conclusions, whenever a criminal trial turns on a value judgment, there is always, to some extent, a risk that it turns on the particular decision of the jury. But that is the place of the jury in the criminal justice system. There is, of course, also a risk of different judges coming to different conclusions as to weighing up a balancing exercise and the like. But when we're, in my submission, dealing with criminal offences, the primacy of the jury in making those value judgments it renders their assessment the appropriate one. In terms of, just finally, on abuse of process as an alternative mechanism, in my submission, the difficulty is it goes back to the need for the fact-finding exercise, that when the facts are in dispute, there is no ability of a trial judge to enter into an abuse of process argument without reaching factual findings on the very points which the jury would be deciding. And so that is essentially to undermine and usurp the role of the jury, to hand that over to a trial judge. Unless I can assist further, those are my submissions.
Thank you very much, Mr. Greenhall. Well, we are most grateful to counsel for your submissions.
I wonder if I could just have 1 minute, that's all.
Oh, yes, Ms. Manson.
I don't want to...
No, I'm sorry. I thought you had given way to your junior.
I have.
But by all means.
Perhaps not rolled over altogether. So, could I just move this? I'd just like to return to where I started, if I may, in relation to the submissions that have been made. And I'm not going to, hopefully, repeat anything. And that's the speech that she made, that I directed you to earlier, which you've no doubt seen by now. It's in the key documents bundle. And the importance of the speech, it still resonates, namely the ability to speak about matters that are touching public importance and require debate and require an element of discourse. And I appreciate freedom isn't absolute and it's a qualified freedom, but this speech encapsulates this problem. And I'm going to put it in practical terms to deal with what my learned friend was attempting to deal with. That's the distinction that he accepts in the Court of Appeal judgment about the organisation as opposed to its aims. And this could be dealt with by a highly crafted summing up. I want to deal with that point. So I'm going to suggest to you, and I wouldn't do it in a way, it'd be interesting to see whether each of you came up with the same answer. Question to the jury. If I say on October the 8th, I support the armed resilience and resistance to unlawful occupation for 75 years. I don't mention Hamas. I don't say anything else, I just say that. What is the judge going to say to the jury? Because I suggest it's a perfectly legitimate, but obviously it's right on the border of everything. What's the learned judge going to say? One judge might say it trespasses, another, are we waiting for cases to come along? I suggest that it's an impractical suggestion that a judge is going to be capable, sorry, I shouldn't use that word, that it's going to be possible for a judge to make this distinction with any consistency between the cases, unless, of course, the proposal that I made this morning about reading in and focusing on what the sort of support is that's being given. Or do I have to... And supposing I go a step further, I haven't mentioned Hamas in that one, but in the next one, I do. I say, listen, everyone, I support Hamas in what they've been doing, defending Palestinians. This was a meeting organised by Palestinians Solidarity Group. It wasn't organised by Hamas. There's nothing in the background of this case that suggests this particular person, this appellant, had dealings with Hamas. She's already explained the literature. She doesn't mention Hamas. She doesn't even mention the acts which I know that the respondent really will probably rely on, the hostage taking. She doesn't mention it. Doesn't mention any of that in this speech. She's doing what a lot of other people would do. So if I say I support Hamas in their resistance to occupation, and they can do it in an armed way, as long as it's not unlawful. In other words, lawful armed resistance. And I've mentioned Hamas in that. Does that make me making a supportive statement of the organisation or its aims? The two of those examples, one not mentioning Hamas and the other mentioning, they're really indistinguishable, and it's a job I would submit that can't easily be done by a judge at all. A judge may be capable of doing it, but it may turn out to be different. Second point, only other point I want to make, is, and it's not this appellant's case at all, her defence statement makes it clear that she had very limited knowledge. She's not claiming she's never heard of Hamas. In the Irish cases, they often go to people's addresses and find there's books on the IRA. That doesn't mean to say they're supportive of the IRA. And it's interesting that the respondents are relying on what she intended to say. In other words, they're saying, oh no, she can't have intended to say that because other speakers spoke about Hamas. Can't be right. That it's dependent on other speakers. It wasn't organised for the benefit or for the purpose of Hamas at all. And the literature's already been dealt with. But the important section here is a situation in which, having, as it were, departed from 12A 1A and the first section A, and we're now passing to recklessness. Now, if, supposing, it's not her case, but a situation in which somebody says, well, let's take the first, either of the two propositions I put, in relation to the recklessness. And we haven't made this point yet, but it is in the written submissions. In a sense, in a public situation, and in a private one, you could say something which is capable of being supportive. So when you say aware of a risk, what it actually means is you can't say anything, because there's a risk attached to anything that you might say in the context of, let us say, the Middle East or Sudan or wherever else the conflict is. And that is why it's another factor which we would suggest means that you need some kind of reconciliation, whether you call it proportionality or something else. That's the test that's still got to be there, because in a sense, as I say, you can say you can think what you like according to the law. You can think that as long as you don't say it. But if you say it and you're aware of a risk, well, how big a risk? Potential risk? Slight risk? Huge risk? Obvious risk? And you begin to see that, in fact, what's going to happen here in these situations is that people will just shut up. It's too risky to say anything that has that possibility. Even if you have no control over it, of course you don't once it's out there, the support that may be proffered may be all sorts of support. But coming back to the objective that this is all supposed to be dealing with, is it to be said that a speech of the kind that was made by this appellant is giving a proscribed organisation a foothold? I think not. Because if it does, if that's the approach that would be taken, then there are thousands of others who make speeches along similar lines under the freedom of speech facility and right that would also become liable. That's all I need to say. Thank you.
Lords, three very short points, if I might.
Yes, Mr. Blackstone.
Firstly, my learned friend in my submission rather downplays the significance of the penalties available when considering whether or not there is a justified or proportionate interference with an Article 10 right. In fact, it's central to many of the judgments in the European Court that penalties are relevant, and of course it's central to the judgment in this court in the case of PWR. So that shouldn't be downplayed. The second point is this. It comes back to paragraph 53 of the Court of Appeal's judgment, which has been raised both by my learned friend Mr. Mansfield and by my learned friend Mr. Mabley. And it's the distinction between the aims of an organisation and support for the organisation. There's a profound difficulty with this because it's in law, it's correct, but it doesn't help an individual to determine what falls which side of the line. Because statements which are expressive of the aims, supporting of the aims of an organisation may well be interpreted as, in fact, supportive of the organisation itself. And it's impossible, in my submission, or very difficult, for a person to know which side of the line their statement is going to fall. So it supports our submission on Article 7 incompatibility. And the third point, really just to follow a submission made by my learned friend Mr. Greenhall, does have to be remembered that juries decide not only the facts, but they very often have to exercise value judgments of reasonableness. And they do in relation to recklessness, because they have to determine whether or not it was reasonable for the person to exercise this risk. And in those circumstances, putting aside the question of whether or not there should be a specific proportionality direction or a heightened meaning direction, there does need, in my submission, to be some direction to the jury, or there would need to be some direction to the jury along the lines of the importance of the right to freedom of speech, Article 10 rights. The jury would need to be directed about that in considering whether or not the defendant's actions were reasonable in the circumstances. Those are my submissions.
Mr. Blackstone, can I just pick you up on the first of the points that you made about the penalties?
Yeah.
Presumably, if someone were convicted of an offence under Section 12(1)(a), the question of penalty would then be for the judge, who would, according to ordinary domestic law constraints, have to make sure that the penalty was proportionate to the offence.
Yes, but...
So wouldn't the judge at that stage, in assessing the penalty, take account of the sort of matters that you were saying would be relevant to determining whether the matter was all to be kept within proportionate bounds so far as Article 10 was concerned?
Yes, but the judge operates within the sentencing guidelines, and it would be relevant to take those matters into account. I accept that. But I think the problem, if I may say so, and the puzzle, if I may say so, about Section 12 is that it has this extraordinarily high maximum sentence. It's difficult to understand quite how that itself is justified. But the sentencing guidelines make it clear that you are vulnerable to being sentenced to sentences of imprisonment. At the very lowest end of the scale, it's said that a community order would be appropriate. But if a custodial sentence is imposed, it means, firstly, that you're treated under Section 278 of the Sentencing Act as a person of particular concern, which means that your sentence you serve longer than anybody else would serve, and you have an additional licence period to serve, so it has that consequence. And if you're sentenced to more than 12 months, then you're subject to notification requirements, which start at 5 years and go up. according to the length of the sentence. So from 5 years upwards, they are 10 years, and from 10 years upwards, they are 30 years. So they are very significant penalties, which you're at risk of.
Yes, thank you.
Yeah, the guidelines, I'm reminded, are in the bundle. I think, yeah, the starting point is 1 year for the lowest category, yes. They're all in there. I thought the court's aware of
the lowest sentence is 1 year imprisonment, you said? I thought
yes, I mean, the starting point for the lowest category is 1 year.
That's if prosecuted on indictment. Presumably,
yes.
There's a lower sentence available if you're prosecuted on summary complaint.
Yes, that would follow, yes. Yes.
Thank you.
Great, thank you very much.
Thank you very much. Well, we're most grateful to all counsel for their assistance. We'll take time now to consider all that's been said and let you have our decision when we can.